Hello, everyone. John Atkinson again here. I'm going to adjust my camera just a little bit here. I'm here talking with Eric today. This is going to be an interesting conversation. He is taking an approach to trying to end the genital mutilation of boys, particularly infant boys, in Florida, and it's a different tactic that I haven't seen yet. So I thought that, wow, this is interesting. So let's see if Eric can explain to us what his tactic is about, how he got to it, and all that. So Eric, please introduce yourself.
Oh, good morning. Thank you, John. I've been working on this my whole life, it seems. Probably fair to say that I had a very traumatic experience when I was circumcised in my first day or two of life. And so it sends one up into their head where, from where they shall never return, it seems. So anyway, I've gotten frustrated by all the talk in activism, and it's all quite noble, but not seem very effective. So I did go to the police station first a couple of months ago and filed a complaint, and of course that was scrubbed clean and buried. And then I don't know why that then ended up at the courthouse. But the fact of the matter is, I guess any state constitution guarantees access to the courts. So you can't just walk right in and request a form for filing for an injunction.
So can you explain to the audience what an injunction is?
Well, it's just an order from the court for someone to cease and desist, whatever it is that they are doing.
Okay. So the idea is to require that those that are cutting children's genitalia without a medical need to cease and desist.
Right. I suppose it's the same thing as what is called restraining order.
Oh, okay.
Yeah.
That's interesting. I've never filed an injunction before. Not being, I'm not a lawyer, not legally trained, so I've never really understood truly what an injunction means.
Yeah. Well, I had never filed one before either, but I'm used to. I guess I hate doing it, but I'm used to filling out forms, and I guess most people are in this day and age. And so, and I find writing my own statements very therapeutic. So to type a one-page explanation out to attach to the request is nothing for me. I can do that once a day easily.
Yeah.
Driving the 30 minutes to the courthouse is the hard part.
Okay. I personally filed a criminal complaint about my own case. I was born back in 1970, and probably like you, back then they weren't using anesthesia of any kind, shape, or form.
Right.
So they just started slicing away,
Yeah.
without any concerns about us screaming or going into shock or anything like that. So
right. Unfortunately, doctors and court workers and people like this tend to live insular lives. I mean, they stay busy. They go to work at 8, and they don't get out till 5. And when they get home, they want to have dinner and watch a movie or spend time with the family. So, they're not spending the time looking at the stuff that we look at.
Yeah.
And so I find, and part of this process of having to go back and back is I'm educating these judges at the same time that I'm trying to get them to, for the light to go on,
Yeah. So can you give us a little more detail about even before you filed the first injunction, you went to the police department and filed a complaint, right?
Yeah.
And I think I saw your form or something about it, and it seemed like they didn't really fill out the form in a way that was clear or that used terminology that made sense. I always avoid using the term circumcision because that's just a euphemism, right?
Right.
My favorite thing is sexual battery of a minor, and as far as I'm concerned, that's what it is. Yeah, if you did something to the of like that, I'm going to be a little funny here, but like if a Catholic priest went and touched genitalia of a 5-year-old boy, sex offender right there, right? I mean, so why is it that a doctor can go touch genitalia without a medical need and without just investigating to make sure that they're healthy, not be qualified as that?
Exactly so. And this is again the thing about the light going on. It's kind of a cliche or something to note to how child abusers are treated in prison. It's not very well. And so I find this judge standing guard for violence against children. And I thought, well, if you were in prison, you wouldn't fare very well for doing that. But here she is, in her glass castle or whatever it is.
Yeah.
So yeah, I am going back this morning with another 1-page supplement. When I do that, there's always 2 or 3 of the same pages of their form that I have to fill in, but it's becoming automatic.
Yeah. Just for the audience, you're keeping a blog of your efforts and stuff on circumcisionasahatecrime.com.
Yeah. On the blog page is always my most recent thoughts. I can barely remember what I put up on the homepage, but that's what people see first. And there are other pages, just informational stuff, I suppose. Without looking at it, I can't even remember what the page headings are.
I'm looking at page 3 and I'm right now looking at mesmerization. Mesmerization is no excuse, which is interesting too. And you were saying that the judge is protecting something. I imagine that the judge is protecting lots of things. One is, maybe in the judge's view, protecting religious freedom. And now a lot of people say, well, it's religious freedom. It's like, I have religious freedom, so I can do this to my child. Like, what about the child's religious freedom?
Right.
Or freedom from religion? And more recent laws have actually clarified that. That each individual should have not just religious freedom to choose to follow a religion or have religious faith, but to be protected from other people's religions.
Yeah, I mentioned that in yesterday's supplement to my filing. I was getting long-winded in my official page, my kind of statement page. So I made a bigger one the way we do to put up on Facebook posts and whatnot, and attached it behind. The child simply has not chosen a religion. In the first week of life. Stephen Svoboda at Attorneys for the Rights of Children made that point in one of his talks. There's
arclaw.org.
Arclaw.org. So, and I hate to even say the word because it's some people's favorite retort. This has nothing to do with diminishing someone's religion. In the case of, first of all, in the case of Judaism, the best intactivists come out of the Jewish faith, which stands to reason because, we're the ones who get cut. They are, and a lot of the ones who get cut. Yep. And also the religion will be diminished, not at all, if it has to conduct itself under the laws of the land, which already should be the case. And in fact, the religion will be increased, I think. Now,
Yeah.
And when people do that, also, this is what I said to the woman that runs one of the sites, Brooke Kim or something like that.
Raheem.
Yeah.
Yep.
And with this gentility, we are slow walking the people that you're trying to protect. You are slow walking them to their next destination. So it's twisted. It's gotten a bit backwards. None of the laws. There's probably 420 ethnicities on the planet, and most of them represented in the United States. And none of the laws divide up rights by ethnicity. None of them. And so
that would be a dangerous thing, because
of course
that would be violating other laws, like equal protection and stuff like that.
Of course. And so when my fellow man gets this protection, it'll be all of them, not just one here and one there.
Yeah. We've seen this, particularly lately. Bills have been drawn up to try to protect females from genital mutilation and intersex genital mutilation, and it's really difficult to draw lines between these three groups, because you got female over here, male over here, and you kind of got this whole spectrum in between. As intersex, it's like, okay, well, where are you going to draw the line? It's not possible, because our genitalia is all developed from the same stuff.
Right. I do hope the listeners will go to my blog and website and look at the most recent blog post. My argument in this filing for injunction is just straight up matter of fact. There's no twists and turns in it at all, because the state of Florida has a statute against female genital mutilation. So you understand the argument that was being made when there was a federal one, which apparently got bounced. But with that and the constitutional requirement, state and federal, for equal protection, there's simply nothing the judge ought to be able to do but grant the injunction. So, and the weirdness about that is, she just has a bigger army than I do. And so there's nothing I can really do about it.
I applaud you for trying. I mean, people often say, how is this legal? How is this legal? As far as I can tell, and I've been looking at this for years and years and years, and I know you have too, it's not. No, it's not written anywhere. It has not been determined by any legislative body that this is somehow an exception to all of the other laws, starting with our own U.S. Constitution.
Yeah,
right?
It's what I've been calling extrajudicial. It's just crazy time. No, but not legal. That's correct. Yeah, no way it's legal.
Yeah. And some people will start comparing it with like clipping fingernails or haircuts. Like you that's not cutting into tissue. That's not live tissue. That's not innervated or vascularized. You kind of start asking the question, okay, well, where do you draw the line? Marilyn Myla says, okay, is it okay to cut here or here or here? It's the very first cut. As long as you get into that innervated vascularized tissue, you've crossed the line.
Right, exactly. The line is at cutting a healthy child is always battery. Yeah, that's the line.
Yeah. Unless it's somehow therapeutic, like cleft lips are always brought up too. It's like cleft lip is like a birth defect, right, or something like that, and you're actually giving the child functionality that the rest of us have,
right?
Not taking functionality away.
Right. Yeah, and of course, you wait until the child can receive anesthesia and describe afterwards level of discomfort and receive care for that.
Yeah, I haven't ever heard of an infant getting cleft lip repairs.
No. Yeah. No.
Always later on.
Yeah.
So the very first injunction that you filed, can you explain a little bit more about what happened or how that got denied? Or what the excuse was for that?
Let me see if I have a couple papers here. The first one, and every page is either displayed as an image on my blog posts, or is found through a link to the documents that I keep in a Google Drive file. So I can't even remember my verbiage on the first one, but my verbiage doesn't change very much from filing to filing. I just read what the judge says in their denial, and it's usually very brief and very wrong. And then, that evening I write in a way that, however the spirit moves me. The first one, I went straight away to mentioning the state statute 82703, which is aggravated child abuse.
Yep.
And the reference to police report, because they ask you if there's ever been any history about this. And it does not appear that I got to the statute on female genital mutilation on this one, but I did reference as documents my own book, Eric Klopper's play, Dr. Goldman's book, The Hidden Trauma,
Yep.
Also Peter Adler's new book, Circumcision is a Fraud and the Coming Legal Reckoning. So the denials, let me see, the denials sound something like this. Order denying petition for injunction for protection against, and I was putting sexual violence, I explained that in the blog, but I didn't want to pick, but it's like they make you pick one. And so, because I usually don't use the term sexual violence, but anyway, it says, petitioner has failed to allege facts sufficient to support the entry of an injunction for protection against domestic repeat, dating, or sexual violence or stalking because, and then underline, there are insufficient allegations of violence. And, which is just not true. And then also number 6, other. So here's what the judge says, which I can't find it in the law anywhere. Circumcision by an obstetrician does not qualify as sexual violence under the statute. Well, again, under the statute, I'm not sure what statute she's talking about.
Yeah.
But that's just why in the next filing, I said, let's do away with the sexual violence reference. It's not, it's not mine.
Like that. Yeah.
And so,
So they're still using the term, well, you're using it too, the term circumcision, which again is a euphemism. And so,
right.
So I'll go in when I start talking to medical professionals and stuff like that. This is prepuce amputation, or at the very least preputioplasty, or another term that's often used is postectomy. Right.
Yes.
So,
yes. And I did, after I brought in the reference to the female genital mutilation, then I did start using the term genital mutilation more. And in fact, in yesterday's supplement that I filed, I did observe in the statute for female genital mutilation. I didn't say I couldn't get it. I said females have access to prepuce amputation beginning at age 18, which, would that be such a hard thing to...
Non-therapeutic.
Yeah, right.
Prepuce amputation.
Yeah.
So I try to avoid words that are heavily emotional. Circumcision on one side and genital mutilation on the other, right? So stick to the scientific terms that people have a lot of time arguing with, right? Or getting emotional about.
I think in my writing style that I actually try to be aggressive. I noticed in writing the book, that I had to call this something so people wouldn't just think it was craziness. And I called it list processing, which Lisp is a computer programming language.
Yeah.
And which what people do when they're coding and what people do when they're writing law, in fact, is their list processing. But for this filing, I rather like to think of it as jackhammering, because a jackhammer is a very violent device. And after a while, people just want it to stop because the noise drives them crazy. So I'm kind of taking that approach, but I'm still at the same time, and it's not always easy. Like I was saying earlier, I left the courthouse yesterday cussing everybody that I saw on the way out the door. But anyway, not at them, but in reaction to what the judge had written. But I'm still respectful. I mean, it's still dear judge and sincerely, and the writing is, while I want it to be as I want to, hit the dam heavily in the same spot each time. Hoping eventually with that and the pressure behind the wall that something will give.
This is definitely a frustrating thing. You're not the only one that's been frustrated with the lack of legal avenues.
I mean, some kind man at the front door of the courthouse yesterday waved me out because five deputies were about to give me the bum's rush, and yeah, it was a very nice elderly man, and intervening in a very kind and brave way. It was funny.
So yeah, it really is kind of surprising that they don't see it as violence. But so you've provided this letter, and you were referring to things like Ron Goldman's book and Peter Adler's paper and book. Actually, the book is released. His book is released now, and I'm actually friends with Peter on Facebook, and he recently responded to me about his book, because I was like, well, so Peter, how is this different than your paper that you've already put out? And he's like, well, I keep coming up with more reasons why this is illegal. So I just decided to write a whole book about it, and elaborating it more than just a paper, legal paper or whatever. And for the viewers that are listening, Peter Adler is a legal professor, not just a lawyer, but a professor. So he's quite the expert on law. It's funny that I could write on this topic every day for the rest of my life and never run out of. I mean, do you need to print out all the stuff from doctors opposing circumcision and all these studies that show that, yes, it's vascularized and innervated and all that stuff? I mean, what is it going to take for someone like a judge to say, okay, here's enough evidence that proves that, it's harmful or whatever.
Right.
To me, it's like really the burden of proof should be on the other side of this, right? Exactly. The obstetricians and pediatricians and the Moyles and whoever else that's doing this should have to prove that it's not harmful.
Exactly.
Right?
So. Yeah.
Not us as activists having to prove that it is harmful. It's always been known to be harmful. Yeah. That was the whole freaking point.
Yes. I sent you in an email just a few minutes before we started what I was writing for this morning's supplement, and I said it doesn't cost you anything to require the doctor to come in. I named one doctor. I mean, I never met the guy. Nothing particular about him, because I want the injunction to be jurisdiction wide. But it is nothing for the court. Let him come in for a hearing and defend himself. And she's standing guard for him. And contrary to her constitutional duty. And that's also in the writing I just sent you this morning. I can read it, but let me do that. I hope I don't lose you by opening up another tab. February 8th, the court case is number is listed. Dear Judge, the court's refusal to extend to juvenile boys state and federal constitutional rights equal to juvenile girls, Florida Statute 794.08, demonstrates how the petitioner discovered that the matter involves a hate crime. This petitioner's supplemental filing for injunction of 7 February is without defect. The judge, in the order of denial, stated, quote, because, ... but without answer. To order the respondent in for a hearing is as nothing in the light of what is at stake, i.e., the equal rights of children to be secure in their person. The judge is selling the law, denying the law, and delaying the law. RE Florida Constitution, Section 21. The courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. The judge is standing guard for violence, for the violation of the rights of children. She objected so much to me saying violence that I changed it to violation of the rights of children. Does it bear stating that that is not a very nice thing to do? In this supplement to the following, the petitioner requests immediate redress, that the injunction be granted, and that the hearing be scheduled. So over and over.
Yeah. Okay. So what was the, so you filed the supplement and you were in court yesterday, you said, yeah. And what was their excuse this time?
Their excuse yesterday, I'm sorry that I'm shuffling papers here because I didn't actually know we were gonna go this way. Boy, I really wish that it's, no, here it is. Yeah, here it is. So let me read this real quick. Again, order denying petition for injunction for protection against, and they have all these categories. And then she checked the box, other, underlined. If either, no, I'm excuse, one above that, sorry. Petitioner has failed to allege facts sufficient to support the entry of an injunction for protection against those types of violence or stalking because, and then, excuse me, after the because, as I was just saying, there's a big empty space. And then below that, she takes another box and says, other. If either party feels the minor children is or being abused, abandoned, neglected, they should contact the child abuse hotline at 1-800-96-ABUSE, which is, just a total dereliction of duty, a total deflection. I feel embarrassed. Yeah, I mean, it's just bizarre.
I've contacted Child Protective Services in various states myself, and I had one case where I cut her mother, a mother that cut her own sons. Argued with me a little bit, but other Child Protective Services people just supposedly took down the information. At least they listened to my reasoning and everything, and what I was pointing out.
Yeah, well, I actually did go online and fill it out because I had, she put the onus on me, so I had to show that I did it. And I got an email this morning saying, we're not looking into that. Don't be ridiculous.
Why not?
Yeah. So, but I would encourage, everyone to go through this step because it's not that hard a thing to do. If they want to borrow any writing from what they see on my website, they're more than welcome. And,
there's going to be slightly different laws because you're in different states, but
yeah. I think that eventually, just pure happenstance or whatever, you'll come across a judge, it'll go, what the hell? Of course, I'm going to give, It'll happen eventually. But they're all, elected and whatnot here. And so they're, just frightened rabbits. Bless their hearts. You know,
Yep. Yep. They're probably afraid of getting, politically, buried or whatever.
yeah. Yeah. I just
Being
also,
called anti-Semites or whatever.
yeah. And all I have to say is I am duty bound, and then talk to Eric, after,
Yeah.
that's all I have to say. Yeah.
There. Well, again, I applaud you for taking those steps. It's and again, I've taken multiple steps myself, and I know that Peter Adler and the Levine family there and David Llewellyn along with them are all taking steps against the AAP and the hospital that the Levine family sons were born. So, and I know that Ron Goldman's efforts, working with Peter Adler, trying to stop Medicaid coverage in one state is going on. So this legal stuff around this whole practice is being pushed.
Yes. Yes. It, it makes one feel hopeful one day, but then the next day you realize that there have, of course, been intactivists since the first routine, sorry for the expression, routine infant circumcision. So we think of it in the context of our lives and who the pioneers were. But of course, they've gone back 3,250 years or more. And they're not all recorded in history. Although in my own writing, does argue that the whole matter of Jesus was trauma. But the book is Jesus and the Unabomber, and I argue that in both cases, the mother came forward after the fact and stated clearly what the trauma was and that it occurred in their infancy. And so I won't go long into that, but, Ted as an adult should not have been killing people, but I see it as the 9-month-old in him doing it. And I find that somehow divine in a weird way. The way the Christians might view the Holy Spirit as doing what it does.
Yeah. Well, it's kind of the history, the legal history of all this is pretty interesting, and how things have been bubbling up per se over the years. One of the first cases, I've been documenting this, and we're actually developing an organization called GALDEF, Genital Autonomy Legal Defense Education Fund, and we'll have a website on that. So coming up here, hopefully very soon. There is a page on Facebook if anyone's interested in that, and we're looking for people to run that organization right now. But back in 1989, and this came up on the Donahue show in the 80s, but there was a case where there was basically a question to the courts: does a parent have the legal power to consent to surgical procedures which have no medical purpose?
Right.
And it didn't get answered, basically. They just, they're like, what's this? And they just tossed it, and then it would go up the chain. And because of lack of funds, it didn't get to the Supreme Court or anything. It stopped.
Right.
But in other countries, in 2012, a German judge ruled that circumcision of a child is an assault.
Right.
And that gave rise to the Worldwide Day of Genital Autonomy, or WWDOGA, if you want to look at that. So, and again, like I was saying earlier, there's a lot of new laws that are coming out across the across the world, really, but even in the United States, local laws as well as state laws. And of course, the anti-FGM law that came out in 97 is when it was active. But these laws, because of trans stuff and intersex stuff, there's all these attempts to create these laws to protect these children, and it's getting very muddied because they're like, like for example, Alabama, someone proposed a law, and someone was like, hey, that outlaws male circumcision. So of course the bill gets pulled, and recently a bill in California was proposed, and actually a second time, and it got pulled too because it's not getting support, because well it all gets muddied up into genital cutting that some people think parents should be able to choose.
Yeah.
So yeah, I appreciate, Eric, you doing what you're doing and making the information publicly available, because that way other intactivists can leverage what you've done and or are still trying to do. and I think there's an opportunity here where people could email or message, write a letter or whatever to the court that you are working with and say, hey, Eric is right, listen to him, and or go file their own injunction at their local court.
Yeah, both indeed. And I also want to say I appreciate so much your work and all of the other intactivists. I was saying that I think mine started at the circumcision trauma, my journey, but I was working in the Kansian fashion up until I was 60. I mean, this was all just, by myself, not really realizing that the movement existed the way it does today. Thank goodness to the internet. So for the last 3 years, they've been no less exhausting, I would say, but very valuable to have this fellowship, essentially. Yeah.
I agree. Sure. Well, unless there's anything else to say.
Let me see your arm.
My arm?
Didn't you have a tattoo?
No.
Who was that? Who was that? That had a victim of?
Oh yeah, I don't know who that is offhand, but yeah, I've seen that tattoo.
Yeah, okay.
Uses a whole
Yeah.
The entire arm is like big tattoo. Victim of male circumcision or something like that. Yeah, I think I've got a copy of the picture on my computer somewhere.
Yeah. My bumper sticker, I printed one of those online services, is under 18 ? Easy lawsuit, exclamation point, and my website address. And of course, on that page, references to the American Circumcision movie, and where it's clearly demonstrated that a young man can go in and be compensated.
Like William Stoll did. He filed a lawsuit, and I guess David Llewellyn was the lawyer, and they found that the mother was still under drugs when they got her signature, and so I guess that was a fairly easy settlement. But the disappointing side of that is that it didn't end up going through court to basically prove that this is a violation or whatever. It would have been nice to see a court actually make something that could be used elsewhere.
Right. It was settled and non-disclosure agreements were signed.
Yeah. So but yeah, I mean I keep hoping that some young man will be angry enough about this before he hits 18 and contact Arc Law or David Llewellyn or Peter Eller or any of these lawyers and say, hey, I want to sue.
Yep. We get some metaphorical blood in the water, and the sharks will do what sharks do. Nature will run its course, but we just keep pounding away.
The reason why it's important for the viewers is that the statute of limitations runs out after 2 years in most cases.
Upon reaching one's majority.
Yeah, and that statute of limitations though applies to medical procedures. Now, my attitude is that's not a medical procedure. That's a ritual that's just being done in a hospital or in a
Right.
medical clinic.
It's
So,
not medicine. Yeah.
yeah,
It's not
so
medicine.
it could be called a lot of other things. Again, sexual battery of a minor. So, as far as I'm concerned, that doesn't fall under the statute of limitations. But lawyers are more likely to take it as long as you've done it before your 20th birthday.
Right.
So,
Right.
all right, Eric.
All right, John.
Thanks again, man. Have a great
Thank you
day.
so much. You too.
All right. Bye bye.
Keep the faith.